that the dophite right for which your lordship directed specifically to government to formulate a scheme and till consider their cases, and till then status quo shall be continued. But here, my lord, under Annexure 7, the Board of Revenue, member Board of Revenue, under Annexure 7, he admitted the facts, everything, as per after making inquiry by the ASO as well as the additional Tahsildar, and but page 34, the impugned order which was challenged before the Honorable Single Judge, my lord, page 34, after admitting his possession, everything as was recorded under the fact rights since the year 1913, my lord, and it was recorded 2007 to 27 and 28. Your lordship, last paragraph, page 34. Therefore, there is no automatic provision to get them changed through stitibar, for which your lordship directed specifically to formulate one of the policy decision to government, and till then status quo shall be continued. And paragraph 10 of my writ petition, I have also stated that, your lordship, in writ appeal page 11, your lordship, can you see page 11 writ appeal?
But this comes to the facts, page 33.
My lord, page 11.
33. Please come to the page 33.
Yes, 33.
Read para 2, sir.
Para 2, the case of brief that the scheduled property to as per 1927-28 settlement ROR had stood recorded in the name of Ghana Sahu, the ancestor third generation of the petitioners, my lord, Ghana Sahu, with 50% share, and Madan Matha, Nila Matha, each 25% share over in total of acre 242 decimal. It is claimed that the area 6.620 as a 50% my lord share, 6 acres 620 decimal share Ghana Sahu. Now the petitioners come from the Ghana Sahu share, my lord, was wrongly recorded in government Rakhit Khata 1962 ROR with note of possession in favor of Birabara Sahu, who is the son of Ghana Sahu, my lord. It is claimed that Ghana Sahu died leaving behind two sons, Digambara and Birabar. Digambara died issueless with his wife Kinabeva, the possession of an area 0.450 decimal out of 6.6 acres 620 decimal. She sold it to Birabara Sahu by a registered by virtue of registered sale deed 4604 dated 1946. It is submitted that Birabara has died, leaving behind his two sons Haribandhu and Krishna Chandra. Haribandhu has died, leaving behind his wife Buddhi Sahu and son Kelucharan Sahu. All three descendants are the present petitioners. A chart indicating that genealogy has been filed. The petitioners have submitted the certified copy of registered sale deed, Sabika Hall information relating to 1929-20 to 1962, Yadas Sabika Hall correction relating to 1962 and 2013, and copies of 3 RORs in support of their claim, my lord. They also filed copy of the previous order of member Board of Revenue in OSS case number 1110 of 2015 dated to 29/11/2016, in which they were given an option to file the present revision petition. The petitioners have sought to record the scheduled land in their favor under a separate khata on the strength of their purchase and possession. Notice has been deemed sufficient to opposite parties. However, no one has appeared.
Read
On-
para 4. Read para 4.
Para 4.
Para 4, my lord. The Tahsildar Jatni has given the detailed report by letter number 11 dated 3/1/2020. The Sabik and Hal status of the suit land submitted by additional Tahsildar Jatni in the status report and submitted by the Assistant Settlement Officer Cuttack Major Settlement in the Paraguay's report are seen to corroborate with the Sabik and Hal status submitted by the petitioner in the present revision, my lord. The report of Tahsildar indicates conversion of the Gochar land to Patit by de-reservation proceedings. However, it is seen from 1929 to 30 record of rights that it was only Dafayati rights, my lord.
What is Dafayati?
Dafayati rights? And
Sir,
that
what is
was granted.
What is Dafayati right?
Dafayati right, my lord, only to enjoy the fruits, my lord.
To enjoy the usufructs of the land. If there is a mango garden, they will be entitled to enjoy the mango.
Ah.
If there is any other, only the usufructory right.
On that basis, you can't get your name entered.
No, that is not the right title interest. It is only a right to enjoy the usufructs of the land.
Rakhit means it's government land.
Yes, government land. Rokhit means government land.
Ah.
It is always Rokhit land means government land.
Ah.
But somebody is given the liberty to enjoy the usufructs of the land.
Ah.
Normally in remote the village areas, so the poor people or the needy people, they are given this Dafayati right to enjoy the usufructs of the government land. And nowadays this type of land,
for entering the names in the ROR cannot.
no, they cannot be entered as a owner of the property.
Your lordship, that is why your lordship already given
No, this is something else.
that order. Your lordship directed
This order is something else altogether, sir.
directed to because they have been continuing their possession since last
Depending on the policy of the government.
3 to 4 decades, my lord.
If the government comes with a policy, then you will take benefit of that.
My lord, my lord.
My lord, lot of writ applications have been disposed of by the same honorable single judge. That whenever any order under section 15B is challenged, notwithstanding the order, the parties are liberty to approach the civil court where the right title interest can be decided. These are all settlement proceeding or fiscal proceedings, and where they are not competent to decide the right title. If somebody is claiming right adverse to the entry in the record of right, then he should have. So I think there is no wrong approach by the honorable single judge. And there are number of writ appeals filed, and nowadays after 15B, all the single bench writ applications are stopped. Nobody is filing. Everybody is going to civil court because this principle has been decided by the honorable single judge. If you are aggrieved by that order and if you set forth a claim of right title interest, then you should knock the door of the civil court and pray for declaration of right title interest.
All right.
My only humble submission, my lord, on basis of the direction given, my lord, now government already.
See, that is separate. If they formulate a policy,
So let them
then you withdraw this to say that you will approach the government.
Let them to consider my case, my lord. as-
Only if you withdraw this, sir. If you don't withdraw this, we have to pass an order on
No,
merits.
that government may not consider because of the
Okay.
order of.
Then we'll pass an order on merits in this writ appeal. After we start dictating, don't say I want to withdraw. We're dismissing your writ appeal, but since you have argued, we will have to pass an order with reasons.
On that basis, I will permitted to order, but on basis of that order.
If you want to, sir.
Forward order, my lord, because
Counsel for the
your lordship
counsel for the appellant.
after hearing your lordship directed specifically, your lordship can see since continuous possession of their more than 100
Anyway,
years.
so counsel for the
And
appellant
your lordship directed their.
states that on the basis of the order dated 23rd June 2022 passed by this court in writ petition civil 2102 of 2002, bracket Brindaban Jaina versus Union of India, the appellants will approach the state government for reliefs in terms of the said order and accordingly seeks to withdraw the present writ appeal.
Your lordship,
My lord,
your
till
lordship may
consist-
observe that this
Dismisses,
court is
withdraw,
not giving any.
liberty is paid for.
Your lordship is not giving any observation on the merit of the case.
No.
My lord,
The court
your-
clarifies that it
your-
does not
your
express any
lordship
view on the
can-
merits of
till
the above claim.
If I will file within 2 weeks, my lord, till consideration.
No, all that.
Let them approach. If they
Yes.
will not consider, then again you will come.
Correct.
Till status quo, my lord, because they will, that farmhouse there is continuously.
Status quo. They withdraw the
All
case,
right,
then how-
within
Item number
specific
2.
period, let them to consider, my lord, civil court, you will approach, but ultimately more, my lordship, because your lordship's order may be implemented, so that government will find it, thereafter he will go to, so till then status quo, at least.
Item 2.
Lordship, I may be pardoned to mention, with your Lordship's permission, I mean virtual, there was a case that has been specifically urgent to take up at 10:30, that is 14706 by
It was
22.
mentioned
Yesterday we have mentioned, we could not, that is adjourned.
It's been
Because of
adjourned
the
to
absence of
9th
the
May.
9th May, sir.
9th May.
Item number 2.
Your Lordship, item number 2 may kindly be permitted to be withdrawn with liberty to file a better application in light of some errors that have cropped up.
This is a writ appeal, sir.
Yes, I'm aware, Your Lordship. If
Counsel for the appellant seeks leave to withdraw the present appeal with liberty to file a fresh appeal.
much obliged, Your Lordship.
This postal is withdrawn with liberty is paid.
Item number 3.
My lord. My lord, this is a PIL read petition, my lord. The prayer is to restrain the outsider to encroach the public road in which they have parked the auto rickshaw and they are encroached the.
Who's
they are,
outsider, sir?
The non-residents of Sutat, my lord.
Come to the cost title, sir. Come to the cost title.
My lord, I have filed an application to implement them as party at in IA, my lord. So lordship subsequently I have filed IA number 2431 by 2022 to implement those outsiders to be implemented as parties, my lord. So against whom I have brought allegation against them as encroachers.
You have not made a representation.
My lord, yes, my lord.
Where is your representation?
The representation, my lord, your lordship kindly see the annexure 11, my lord.
Yes.
My lord, page 36, my lord. 36, 37, my lord.
Is
Where's the
37.
representation?
37, my lord, that is the annexure 1, my lord. And that is. I'm sorry, my lord. I'm sorry. My lord,
No,
sorry.
that
My lord,
page
annexure
14.
page 14. Yes, my lord.
1-4.
Page 1-4, my lord. Sorry, my lord. 1-4. That is 1-4.
And
Yeah, 1-4.
this representation relates to a particular function. I think that is already over.
Yeah, 2020 representation.
This is 2020. Then
My lord, they are not, they are illegally, they are parking their auto, they are
Make a fresh one,
they are
sir.
taking liquors.
The last representation made by the petitioner was more than 3 years ago, permitting the petitioner to make a fresh representation to the authorities and after following up with such representation to seek appropriate remedies in accordance with law. The petition is dismissed.
Item number 4.
None
Item
appeals.
4.
None appeals dismissed.
Item number 5.
Same order.
Item number 6.
Same order.
Item number 7.
Same order.
Item number 8.
The fraud, the village, entire village was affected 2022 from fraud in the month of September, my lord. And they have not received any relief, my lord. And that is, they have obtained annexation of 2, my lord, through RTI. And that amount was disbursed in favor of some villagers. But they have not, practical, they have not received, my lord.
Where is the proof of submitting the representation?
And they have filed the representation under annexation 1 to the collector, my lord.
Where is the proof of submitting representation?
That is annexation 1, my lord.
no, proof.
But proof.
That through post, my lord, but I have not annexed the receipt, my lord.
Permitting the petitioner to make a fresh representation with the authorities and after following up with such representation to seek appropriate remedies in accordance with law. Petition is dismissed.
Item number 9.
Please, my lord. Yes, my lord, all those petitioners, they are the villagers as well as the beneficiaries under the Fayati rights case number 1/13, my lord. Here, my lord, annexure 1 series, you lordship may have a glance that in these documents, about 45 beneficiaries along with others, those are not before you lordship, they've been allotted 2 acres of land each for which they have to raise plantation.
Where is the proof of making representation?
Yes, my lord. This is, my lord, pursuant to our
Proof, sir.
proof. Yes, I am giving annexed 2, may kindly have a glance. With reference to the subject cited above, directed to cause an inquiry and submit a report to the grievance petition enclosed herein.
All right. You see,
Point wise and demarcate the following
all right.
lands.
Counsel for the petitioner refers to a letter dated 20th March 2023 written by the Tahsildar Potangi to the Revenue Inspector asking him to conduct an inquiry into the grievance petition of the petitioners and to hear them. It is submitted that no action has been taken on the above letter. In that view of matter, direction is issued to the Tahsildar Potangi to examine the petitioner's representations, bracket annexes 2 and 3. And after giving them a hearing, after giving a notice to the petitioner and opposite party number 6 and giving them a hearing, to pass a reasoned order, not later than
Here, my lord,
1st July, and to
may-
communicate the order to the parties within a week thereafter. The court clarifies it is not expressed in any matter.
Item number 10.
may I pray, my lord, pursuant to annexure 2, my lord, we all the parties, they have been noticed. All the parties, they have been noticed. Here, my lord, their only intention is to extract or excavation of stones from the nearby stone court, against which we have represented.
All right.
Here, my lord, at least interim protection not to proceed with the
That you asked the Tahsildar to do. So.
already lease has been granted. Successful bidder has taken steps for excavation.
Have you made him a party?
Yes.
So we've asked him to be.
Annexure 6, opposite party number 6, I have implemented as
We
party.
passed an order for that, sir. Yes.
Item 10.
May I please, Lordship, my lord? The shape of PIL, my lord, is the illegal construction over the government land, is Rakshit land, the construction of the water canal in the government land, my lord. I have filed a petition on annexure 3, my lord, pending before the OP number 2 collector.
All right. The petitioner's representation, bracket annexure 3, will be examined by the Tahsildar Remuna.
Tahsildar Remuna, my lord.
And after notice the petitioners and
So
opposite
pending
parties,
annexure 3 is pending before the collector.
5 to 10.
5 to 12, my lord.
And after giving them 5 to 12, and after giving them a hearing, the reasoned order shall be passed not later than 15 July, and we communicate to the parties within a week thereafter. The court clarifies it is not expressed.
Deep level.
Item 11.
May I pledge LRCs? The PIL LRC present petition is the whole student of the school LRC. There is 8 sanction post of the teachers LRC, but now the school is going on only 3 LRC, 3 teachers. Which I have repented to the authority LRC under annexure 1 series, page 14 LRC, which is pending for the OP3 LRC. LRC may direct to consider. In page 6, para C, I have stated that the total strength of the
No, where is the representation?
representation is annexure 1 LRC, page 14.
14.
14, 1-4 LRC. Started with 1-4
What is it
LRC.
sent by email, is it?
E of Vijog. The given in the E of the details of the E of Vijog I have given in page 20
This
LRC.
was made 2-3 years ago, sir. Where is
Yes,
your recent representation?
LRC. The subsequently also I have given the representations annexure 4 LRC, page 35. I have given to the chairperson also National Commission of Protection of Child Rights LRC. I have given to annexure 4.
So why don't you approach there? They have a mechanism, sir. NCPCR has a mechanism. You've already approached them. They'll treat it as a application and inquire into it.
Yes, LRC.
There's already a forum for these things. You've approached the right forum.
Page 38 LRC. Kindly see
You've
there.
approached the right forum, sir. Once you've approached the NCPCR, you should follow up there only.
So the page 38 LRC kindly have a glance. on 28/6/2022, they have also written to the Principal Secretary School and Mass Education
Correct.
to look
Now you
into
should ask them to register your case as a complaint and they will inquire into it and they will do
But,
directions.
that is also pending. The authority has not
No,
taken
you
any
have to.
step.
You have to go before the NCPCR, sir, permitting the petitioner to follow up on the applications already made to the National Commission for Protection of Child Rights. In accordance with law, the present petition is disposed of.
So they have directed to the Principal Secretary School and Mass to
You have
look
to
at the
just
matter.
follow up there. You have to follow up there. Yes.
They have not taken any step, Your Lordship. During pendence of that, Your Lordship, now the 1 month back, Your Lordship, another teacher have been deployed to other teacher, Your Lordship, other school, Your Lordship. Your Lordship, may direct the collector to look into the matter,
Not
Your
really.
Lordship.
Not. Yes.
Item 12.
My item 12, 13, 14, 8th May.
8th May.
Saptaparda.
All right.
Item number 15.
None appeals dismissed.
Item number 16.
8th May. All right.
Item number 17.
None appeals dismissed.
Item number 18.
Matter already infructuous.
All right. Disposed of instructions.
Item 19.
Item 19, there is a defect. Certified copy not filed, but by mistake we have sent me. The small point is, Your Lordship will kindly turn to this brief. We have challenged the order as it has been passed pursuant. Your Lordship may kindly turn to page 66. Page 66 will indicate the position. This order has been passed relying on the judgment passed at page 66. I have only that portion. There was a rule about the promotion of the Coal India. Subsequently, Coal India by a circular changed some portion of the rule. But this Honorable Court at page 66 Millers has changed hold that there is no dispute in the matter of statutory provision cannot be changed by administrative instruction. This judgment review has been filed. So the review has not yet been listed. Review number is review petition 240 of 19.
All right. Mr. Shakshidhar Das, Senior Counsel for the Appellant, informs the court that a review petition filed against the judgment dated 2/4/2019, passed by the learned single judge in writ petition civil 1643 of 2012 is pending and accordingly requests that the present appeal be deferred. See, next line, list on 4th September.
Obliged.
Item number 20.
May I please, Lordship? Item 20 identical with the yesterday list, item number 15, Lordship. Pass on similar order, Lordship, I am submitting.
You are the order. You see, yeah, same order as yesterday's item 15. All right.
Obliged.
Item 21.
My Lord, there is a petition application for continuation of delay, that is IA number 2183 of 2022, that has not come along with this case.
What is the matter about?
Matter is relating to payment of ex gratia compensation amount by the bank to the petitioner's matter. And the bank has decided and observed that they will pay the ex gratia compensation as per Annexure 2 mail. And due to non-submission of the appropriate format, the bank could not pay the amount to the petitioner's matter. And the Lorna single judge matter, so far as the prayer in the writ petition is concerned, there are two folds matter. One is for payment of ex gratia compensation, another is for compassionate appointment matter. And by the order of the Lorna single judge matter, I have also submitted the required form to the bank for payment of ex gratia compensation on 33/2017 matter. That is also in the writ petition matter. And the Lorna single judge only considered the compassionate appointment part. So far as the ex gratia compensation part is concerned, that has not been considered.
Counsel of the appellant, seeks time to cure the defects. List on 5th July. Defects be cured.
Item 22.
Particular DLR employee regulation matter, 25th of April, madam.
All right.
Item 23.
None appears dismissed. Memos taken in record, disposed of is withdrawn. Right.
Item number 24.
Infructuous. Infructuous disposed. Right.
Item 25.
25 is my lord, DLR 25th of April, madam.
All right.
26 same, madam.
All right.
Item 27.
Item 27, my lords, there are some defects, my lords.
No, this is 2021 matters. Tell us.
My lords. There, my lords, the case, my lords, may presented on merit, my lords.
Yes.
My lords, the case is that, my lords, the opposite party number 1, my lords, has a unit in the name of opposite party number 3, Eve Thermal. Eve Thermal, there are a number of employees, and for the purpose of to facilitate education to their children, the institute decided to have a school. And as per the Education Act, matters, there is a there should be a management, and accordingly, management was constituted by their officers. And the petitioner was appointed as a teacher by them. Subsequently, the school management of the school was transferred to opposite party number 7. Thereafter, in the meanwhile, the management was also transferred subsequently to in favor of opposite party number 9. Well, fact remains, my humble contention, I have come before the Honorable Court that I was appointed through a committee constituted by the opposite party number 1. So I should be treated as an employee of the opposite party number 1. I have retired, and all my retirement benefits and all these things should be given by the opposite party number 1. The Honorable Single Bench held that yes, these document shows particular to A, annexure to A, that we are appointed by the society, the secretary of the particular society registered under the Society Registration Act. So we cannot be an employee of the management. That is what the specific finding. The only thing is that unless there is a society, there cannot be registration and all.
Become an employee of the
only thing is that whatever matters to decide because I understand. Thing is that the opposite party number 1 constituted it for the purpose that yes, these facilities should be given to the student, and their officers were the management, and they have given appointment.
The challenge in the present appeal is to a judgment dated 4th October 2021, passed by the single judge, dismissing writ petition civil. The OJC number 7047 of 2001, filed by the present appellant, claiming that the Orissa Power Generation Corporation Limited, OPGC, should come up after treating the appellant to be its employee, release arrears of differential salary in the revised pay scale, and also give her all the retirement benefits. Paragraph. The question before the learned single judge was whether, as claimed by the appellant, she could be treated as an employee of the OPGC when in fact she was appointed as a teacher in an Odia medium school in the name of single quotes Eve Thermal Vidyapitha, unquote, within the compound of the OPGC project.
May I only disturb 1 minute, that I think it will give a clarity of dictation. Kind of a class to page 42 only.
Yes.
42, subparagraph 3. So there, the agreement entered into, it itself indicated that Odisha Power Generation Corporation established Odia Medium School at Banarpali under the name and style Thermal such and such for the benefit and welfare of the employees. So they themselves admitted that it is
setting up is one thing.
Yeah.
It was found by the learned single judge that the school itself was registered under the Societies Registration Act 1960 and therefore was a separate entity. No document was produced to show any privity of contract between OPGC and the appellant. So, in fact, it was the school that had been confirming the services of the appellant from time to time, and also made her in-charge headmistress with effect from 30th June 1996. Full stop. Paragraph. In the above factual background, the finding of the learned single judge that the appellant cannot be treated as employee of the OPGC requires no interference. Full stop. The court is unable to find any ground to interfere. The appeal is dismissed.
Item 28.
Yes, sir. 8th May.
8th May.
Item number 29.
Lord, I am appearing on behalf of my counsel, Lingaraj Sarangi. He is not able to appear because his mother is ill. Kindly request for another
Alright.
day.
List on 6th July. Defects be cured in the meanwhile.
Thank you, Mel.
Item number 30.
Memo taken on record. Dismissed as withdrawn.
Item 31.
At 13th September. Work, sir.
Item 32.
None of it is dismissed. This is your matter, sir.
32.
Well, the appeal is filed against the judgment passed by the Honorable Single Judge, my lord. But before that, my lord, kindly have a glance to paragraph 12 at page 10, my lord. Against the judgment, SLP was filed before the Honorable Apex Court that was dismissed without.
Then that's the end of the matter, sir.
My lord, but it is dismissed only at dismiss.
That's all. The common
But as per this judgment of this Code Distillery versus my lord, it is.
You see, the impugned judgment was common to several writ petitions. And against the judgment in one of them, SLP Civil, where's the copy?
SLP number 16724 of 2022.
Where is the order, sir?
I'm not annexed, my lord.
Show us the order.
I'll file it during the recess, my lord.
What is that? 16732 of?
16724 of 2022.
Was filed at the Supreme Court of India, which was dismissed on
26/9/2022.
26/9/2022. In that view of the matter, the present writ appeal is also dismissed. Right.
Item 33.
My lord. So these similar matters are kept to 14th of September.
No, that is not a similar matter. I think that is a work charge. My contention is
that I have this file was traced on in the morning. I haven't gone through, but similar matters.
That's a different issue.
Because this next matter.
By my learned friend has not gone through this matter, there's no problem. But it's not at
that is what I was going to say, my lord.
Daily wage. It is not regularization of daily wage.
I'll go through the file, my lord. Should I call it?
Well, so be pleased to take it. Well, if person is suffering well, but since 1994-95, juniors have been taken into work charge establishment and he has not suffered because of his date of joining was disputed. If my learned friend has not read it, so I think I might.
All right. At the request of counsel for the appellant, list on 4th July.
May before that, this man is suffering since 1993-94 minors.
All right, 22nd June. All right.
Item 34.
May I please, my lord. The writ application has been dismissed only on the ground of delay, my lord, 5 years. The petitioner, my lord, happened to be a lawyer. And the aggrieved person, the petitioner, is a lawyer. The file was misplaced. His personal file was misplaced in the house. So he filed there. There was a delay, and merits have been there. That has not been considered. My latest decision to 2020 Supreme Court Wait India case that only on the ground of simplicity it cannot be dismissed, my lord, without considering the other aspects, my lord. Here the merits, my lord.
What is this UV case number 1?
Sorry, my lord.
What is UV case number 1?
UV case. UV case number.
The value is stamp duty. What is all this, sir?
1 of 2016. Well,
What is the
your lordship may kindly have a glance to that decision, my lord. Paragraph 2,
blacklisting, sir?
it's a 10-year delay.
Blacklisting is so different.
No, it's
everything.
different also.
The context is to
So
see.
paragraph 2, delay 10 years. Paragraph 14, when the principle has been laid down, paragraph 14. Paragraph page 5.
Blacklisting continues for 10 years, sir. So it's a continuing cause of action.
Sorry, my lord.
The blacklisting itself was for 10 years.
No, your
So
lordship.
it was a continuing cause of action, sir.
No, that's what the court has decided differently.
All these are discretions.
Sorry.
Para 14 also talks of the discretion of the High Court.
Okay.
It's
Discretion
not a rigid formula that in every case, irrespective of delay, we have to intervene.
But the court has said that if no third party right has been created, these are the aspects. My lord, your lordship may just have the ratio, my lord. May I please just be permitted to read for 2 minutes?
Please read.
That brings us to the question of delay. There is no doubt that the High Court in its discretionary jurisdiction may decline to exercise the discretionary jurisdiction on the ground of delay in approaching the court. But it is only a rule of discretion by exercise of self-restraint involved by the court in exercise of the discretionary equitable jurisdiction and not a mandatory requirement that every delayed petition must be dismissed on the ground of delay. The limitation acts stricto sensu do not apply to the writ jurisdiction. The discretion vested in the court under Article 226 of the Constitution therefore has to be a judicious exercise of the discretion after considering all pros and cons of the matter, including the nature of the dispute, the explanation of the delay, whether any third-party rights have been intervened, etc. The jurisdiction under Article 226 being equitable in nature, question of proportionality considering whether the impugned order merits interference or not in exercise of the discretionary jurisdiction will also arise. This court, then relying upon various decisions, held that if the delay is properly explained and no third-party rights are being affected, the writ court under Article 226 of the Constitution may condone the delay holding as for. Here, no third-party right has been created. But what the merits also, your lordship may see, 2006, my Vendi, when he purchased the land, there was an undervaluation case. And the collector came to a finding after inquiry that the per decimal land is 6,250. 2 years after when it was sold to me, they went back to again that old rate of 27,000, which has been reduced to 6,250. And again, now they say that I have to pay at rate of per decimal 27,000 with the increase for 2 years. That's about 45,000 per decimal. All that the previous undervaluation case has not been considered neither by the collector nor by the district judge. That's a material irregularity there. And here, no third-party right been created. I mean, he's not an ordinary person. He's a petitioner, he's a lawyer, where he has a lot of files in his office. So this particular file, his personal file has been misplaced. And so he was not able to file within time. There's only on that ground, the honorable single judge had dismissed the writ application without considering any other aspects. I could have been imposed, my lord, some cost, my lord, that also for whatever laches, my lord, on my part.
No, but I'm not able to understand. The lawyer was the purchaser of the property, right?
Yes, the lawyer has purchased the property.
My lord, what has happened? This is
He has taken possession of the property.
He is in possession. He is in possession of the property.
There is,
very happy
in possession.
position,
It is only realization of the
without paying stamp duty for over 10 years.
yes.
No, my lord, what I'm
only
saying,
realization of the area government revenue from the person
So you
who
do
has
one thing.
purchased
Without
property.
prejudice to your rights and contentions, you deposit the amount with some interest because government has lost so much money. You're disputing this stamp duty and registration fee, right?
Excess.
What is it? What does that work out to? What is that excess working out to?
That's about.
Your lordship may see the order of the honorable district judge. He has explained everything at page 66.
He has charged at the rate of 45,564.
How much do you have to pay? Sir?
Yes, just.
How much are you required to pay?
Yes, just.
The district judge has said the valuation has to be at the rate of rupees 45,564 per decimal, which is the market value of that area. And he has paid stamp duty on a low valuation. The differential value has to be paid. That is why the UB case has been initiated.
Correct. So what is the differential value?
That I have to calculate. The figure has not been given in any way.
So you calculate that figure.
Yes.
And then with any nominal interest, let's say 6% simple interest, from the date it was due, when was the sale deed executed?
2010, my lord.
So for this 12 years, calculate that interest and you deposit it in the treasury and produce a slip. Then we will consider issuing notice.
Yes. Let me grant me some time.
Mr. Udgata states that the appellant will, without prejudice to its rights and contentions, deposit in the government treasury the differential stamp duty in terms of the calculation given by the district judge.
District judge. Confirmed by the district judge. It is by the collector.
Confirmed by the district judge. Your Lordship may see, he has executed the sale deed at the rate of 5,000.
As determined by the district SAM collector.
Extremely high.
And confirmed by the district judge.
Together
with simple interest at 6% per annum on the said amount from the date of the execution of the sale deed, that is, what is the date of the sale deed? 1/2/2010, and produce in this court proof of deposit of the above sum. Mr. Udgata says that the sum will be deposited within a period of 4 weeks from today. All right. For reporting compliance with the above undertaking given by counsel for the appellate. List on
obligation. Urgent copy.
21st June.
Item 35.
At 35 में 14th September work sets.
36.
None appears dismissed.
I don't know, 37.
Work set.
36, man. 36.
36. 36.
The second round of litigation, my lord. Earlier, the writ appeal was filed against the order of the Lord single judge, and my lords was pleased to set aside the said order and direct the Lord single judge to dispose of the writ petition in the light of the notification of the year 1989. That he has power to entertain and conversion proceeding. There, the homestead land was converted to as a road because of the nature of use that the parties are using the said portion of land as a road to access of their to their residential houses, my lord.
And we've been given power to go to the civil courts. All disputed questions. There are rival claims, sir.
My lord, with that specific observation, the writ appeal was disposed of, and the direction was given to dispose of the writ petition, my lord, in that view of the matter. But the Lord single judge, Lordship may kindly have a glance to the order that
8, sir.
My lord.
Come to para 8 of the impugn order.
Para 8. The court, going back to the claim and rival claim of the parties, finds when opposite parties as the petitioners in section 37(2) proceeding claims, let there be change in the kism of the land as private land instead of homestead land. Case land is being used as a road. The opposite parties therein, the parties herein oppose the claim of the petitioners therein, saying that they uses the disputed land as homestead in Kisham. This, in the above background, looking here, the purpose behind the act, this court finds there is no wrong order passed by any authority subordinate to the director requiring to exercise the power under section 37(2) of the act. Further, for the scope under the act, and prayer since involved an easementary right, even if a consolidation proceeding is concluded, the matter should have been decided by common civil forum, my lord. This is the observation given. So what I beg to say that 37(2) power of the consolidation authority is an advisory power, my lord. And illegality committed
by the forum after the preparation of the record of right was interfered with. So now, by saying this, the Honorable Single Judge has committed an error departing from the direction given by this Honorable Court in the earlier writ appeal, my lord.
What is the direction in the earlier writ appeal?
Direction, my lord.
Where is that?
Paragraph 18 of the brief. I have quoted it at paragraph in the order. It is in paragraph 3, my lord. It is apparent on the face of the impugned order dated 19th of March 2018 that the attention of the Honorable Single Judge perhaps not drawn to the above Amendment Act. Consequently, without expressing any view on either of the contentions of the parties on the amended provision as recorded above, this court, while setting aside the impugned order of the Honorable Single Judge dated 19th March 2018, restores the OJC number 13450 of 2000 to the file of the Honorable Single Judge for being considered afresh in the light of the above amendment provisions. The petition will be listed with the
notice returnable. You accept
Lords,
notice for?
Lords, I am appealing for the respondent number 1, Lords.
1.
Lords, I am the contesting opposite party, Lords.
All right. He
Lords,
accepts
here,
notice.
Lords, the writ appeal is, may I submit, Lords, one thing, Lords.
No, there are some 1 to 15. There are 15 respondents, sir.
They are not contesting, Lords.
They are not.
Only Madhusudan Pradhan.
So far, record of right is concerned, my lord, there is no dispute between the parties. Only with regard to Kisam, my lord.
1 minute. The appellant is 90 years old, correct? Your respondent 1,
Lords.
Your Madhusudan Pradhan.
Madhusudan Pradhan and Lords, they are the legal heirs of Mongoli Pradhan, my Lords.
So 1 to 5.
Madhusudan Pradhan.
1 to 3. 1, 2 and 3.
1, 2 and 3, my Lords.
But the others are not shown as pro forma. The others are not shown as pro forma. So he accepts notice for 1, 2 and 3. Notice to the remaining response. I think state is also there.
State in view of
Das accepts notice for 16 and 17.
Writ appeal is not maintainable, my Lords, because this the Honorable Single Judge has passed the order, Lords, exercising the jurisdiction under Article 227.
This is last time also same thing happened. We remanded Lord, that time you didn't raise any objection.
Lords, last time only on the ground that the writ petition, the OJC was disposed of only on the ground that Consolidation Act is not applicable to homestead lands. On that ground,
anyway, the preliminary objection, a preliminary objection is raised by counsel for the respondent as to the maintainability of the present appeal by contending that the learned single judge was exercising jurisdiction under Article 227 of the Constitution. What do you say to that?
Well, it is maintainable manner.
How?
It's maintainable manner because the single judge has exercised his jurisdiction against an order passed by the consultation authorities.
Correct.
Yes.
It is under 227.
That is under 227.
227.
That is a full bench decision.
Lords, that is Lords reported in 2008, volume 2 OLR.
Yeah.
Lords, page 725.
Cause title.
Right. Lords, case of Muhammad Saud and others.
Correct.
Lords.
Indeed.
I'll give my reply on the same matter.
Single judge was exercising jurisdiction under Article 227 of the Constitution. Then by virtue of the full bench judgment of this court in Muhammad Saud, which was affirmed by the Supreme Court in Muhammad Saud again, the present writ appeal would not be maintainable. Paragraph. Counsel for the appellant is unable to dispute the above factual position regarding exercise of jurisdiction by the learned single judge while passing the impugned order under Article 227 of the Constitution. In that view of the matter, leaving the appellant to avail other remedies as may be available to the appellant in accordance with law, the present appeal is disposed.
Item number 37.
My lord, may kindly keep it open. I will satisfy your lordship on that issue, my lord.
Late.
Because my lord, this is a consolidation proceeding, my lord. So far the civil courts are concerned, single judge of the single judge, order of the single judge is not applicable. It is already discussed there. I will differentiate, my lord. Lordship may kindly take it up next week, my lord. Any
Not right. After dictating the order, don't say this, sir. Yes.
Item number 37.
14th September, my lord. What says?
14th September.
38.
38th में 8th में शर्त पड़ा.
All right.
Item 39.
39 DLR में 25th April.
Right.
Item number 40.
Job contract 14th September.
Right.
Item 41.
41 में शर्त पड़ा 8th of May.
All right.
Item 42.
42 is job contract 14/9.
Item 43.
43 में work charge 14/9.
Item 44.
44 में 14/9.
Item number 45.
14/9.
46.
My please, my lords. Here, my lord, writ appeal filed, my lord, against the order of honorable single bench at Annexure 5. But here, my lord, I have to file a limitation petition, my lord.
All right. We say list on 4th July. Defects be cured in the meanwhile.
Item number 47.
And 47, my lord, I filed the impugned order by Monday, my lord. I have not filed. It's a writ appeal against the order of single judge, my lord.
Impugned order file कौन?
Impugned order file कौन?
For High Court.
You have copy, खाली net copy. I filed the net copy. The impugned order.
The same.
Government file.
3rd July. Defects be cured in the meanwhile.
3rd July.
Oh, bless.
Item 48.
Your lordship, in similar case, issue notice on 12th July.
Same order.
Item 49.
Same, 48, 49, same.
Item number 50.
Rehabilitation 30th August.
Item 51.
Rehabilitation was 30th August.
Item 52.
52.
52.
Similar matter, lordship issued 4th August. Sorry, 26th September.
Item 53.
53, 54, 55, 56 per hour job contract 14th of September.
14th September. Item 57.
57 outsourcing 8th August. 57, 58, 59, 60, 61. Outsourcing 8th August.
62.
62 and 63 minutes शर्त पड़ा 8th of May.
64.
64 64 outsourcing.
8th August. 8th August. Item 65.
Sorry, my 64 शर्त पड़ा. 64.
85.
85.
Item 65.
65. Sorry, madam. 64. On last click on lordship heard this matter, and I have filed an affidavit to
Squad report. You wanted to find out if the
yes, my lord.
Squad report was supplied.
Yes, my lord. I have filed an affidavit. Your lordship, see my affidavit.
Where is the affidavit?
That in that affidavit, that annexure I have given, and I'll place the inquiry report and the documents which we have supplied. Your lordship, that affidavit annexure A series to my affidavit, page 7.
You have another copy? We don't have the affidavit. When did you file it?
Yeah, I'm giving my 18.
Have you got a copy?
My lord. On 18/4. The document which has been supplied to me, that has already been in my annexure 6 series of the writ petition. That
Yes,
6 series they have supplied now.
Oh.
Yes, I'm.
So that's not
No.
included the squad report.
No, my lord. Your Lordship may see page 31 of the writ petition, page 31 of the appeal. They have clarified what is the squad report, and that has been refused. Your Lordship may see that annexure A by series, your Lordship may see.
Tell us which page is the squad report?
Page 7, my lord, of my affidavit.
Supply squad report.
Your Lordship may see. Copy of the inquiry report, copy of the report of the collector Moyurbhanj on 2 TRCS, copy of the report of PD DRD Moyurbhanj on 2 RTCS, Dantia Mohana TRCS, Sarat TRCS, copies of the consolidated joint verification report on Tosar plantation of 5 joint squad consisting of 5 members, so and so, my lord. And these reports we have been taken into account during the course of inquiry. No other report. Your Lordship can find from the inquiry report. What was the inquiry report? That he is insisting on
squad report.
Yes, ma'am. He is insisting on squad report that is non-existence, and we have not relied upon.
Oh.
Your Lordship, see the inquiry report. Page 31. Your Lordship, page 31 of the writ appeal. What squad report they have relied upon? This is the letter of the inquiry officer. Page 31 of the writ appeal, annexure 5. After completion of the inquiry, I asked for the inquiry officer that please supply the documents as well as the depositions and cross-examination I have made, my lord. That has been, my lord, it has been mentioned. Page 31. Kind reference to your department letter number so and so. The above named subject, the copies of the squad report of S.N. Patnaik ADS, S.K. Acharya ADS, Srimati N. Biswal ADS and D.P. Das special has been supplied to Sri Das. Thereafter, my lord.
No, so this has been supplied.
So not been supplied. That has I disputed. That has not been supplied. Your Lordship may see.
No, but this page 7 of this affidavit.
My lord, in the left side column, one. I have when I received all these, I have indicated received the letter of the squad consisting of I have not received. In Biswal and so and so. I disputed this. Thereafter, my lord, after this 2009, the government come off, my lord, your Lordship, page 97. Your Lordship, page 97 of the writ petition, what they have the government said. The government said, my lord, in 97, page 97, that in the said para 2 of the compliance report filed so and so, the aforesaid squad leaders N. Biswal, S.N. Patnaik, ADS, D.P. Das, Special Officer, never conducted inquiry into the plantation of Sarat and Dantia Mohana TRCS. Well, if the inquiry officer under page 31 of the annexure 5 of the writ appeal said that this has supplied, the squad consisting of so and so has supplied, my lord, now they are saying they have not visited the spot and no report was there. This is the one part. So far as second part is concerned, as regards copy of the cross-examination report, it has been submitted there. The inquiry authority, along with the 2 files already submitted, there is no such record before the inquiry officer. My lord, what they have said, my lord, your Lordship may see the page 88 of my writ petition. Whereas Dras has not cross-examined. They are saying when I asked for the cross-examination of the witnesses, the disciplinary authority is saying you have not cross-examined. Now the inquiry officer is saying the cross-examination along with all the reports have been submitted to the disciplinary authority. My lord, the inquiry report, your Lordship may please kindly, the page 8 of the affidavit, they have given the inquiry report. The second paragraph.
80.
My lord, 8 of the today's affidavit. The second paragraph. Sri Das henceforth called upon the delinquent has been charged with so and so. My lord, the middle portion as such, deposition of so and so person, president, branch of TRCS, so and so manager and so and so. My lord, the thereafter, and Prafulla Kumar Das has been recorded the statement and they were cross-examined by the delinquent. If the inquiry officer is saying I have cross-examined, I asked for those documents. Now the disciplinary authority said you have not cross-examined. This is my lord second point. And so far as my lord,
This page 31 is concerned. They have supplied me certain documents, which is the squad report of that two TRCS, Dantiamu and Sarad, was not there. I asked for the document, and finally I come to before this honorable court. This honorable court in division bench specifically directed you supply the inquiry report along with the squad report. That squad report has been clarified by page 40 of the writ petition. The squad report relates to Dantia Mohana TRCS and Sarata TRCS. Thereafter, my lord, they have supplied this bunch of documents which I have annexed 6 and the affidavit they have filed today. This bunch of document I have received in absence of squad report. I asked for the authorities, please supply me the squad report which the inquiry officer relied upon, and it has been submitted to the government. They have said in 97 that they never visited those two spots, and the report is not in existence. Basing upon this, my lord, the inquiry officer come to a conclusion, my lord. In page, your lordship may see the inquiry report, that is page 9, which has been given in the affidavit. Page 9, the relevant portion is, my lord, that is page 11 of the affidavit. Even though this is the observation of the inquiry authority, even though a straight line cannot be drawn regarding the maintenance cost of the plants, but taking into the area found on measurement, the witnesses of the secretary and the visiting report of the squad, and the officers and looking into the production aspect, it can be concluded that maintenance of plantation have suffered drastically and haphazard maintenance has been done. I found 40 to 60% of maintenance costs have been utilized. This is the observation of the inquiry officer, my lord. And moreover, my lord, this inquiry report, whatever squad, whatever verification report they are relying upon through this affidavit, my lord, all has been done after the conclusion of the inquiry, my lord. The last date of inquiry was 98, and all this report has been prepared after by closure of the inquiry.
Lordship, I turn to page 10 of my today's affidavit. That is the inquiry report. Lordship, I'll just place the 4 lines at the bottom, my lord. Lordship, there is an annexure 2. This I have also requested the collector Baripada to take measurement of sub-field plantation. The report submitted by after measurement in presence of the delinquent is also annexed annexure 2. This report shows there is plantation of Hatkuta 19.8.
I have also requested, this seems to have been made after the inquiry was concluded.
Yes.
So how can it be behind the back of the...
No. What I am relying. This report shows that there is plantation of Hatkuta 19.8, 30.5, Rangumita 8. Thus, there is some shortcut. Then you will also turn to last line. Measurements of the field of plantation of the center Mayurbhanj district were taken up by a joint squad framed by the collector and by the director involving revenue means and technical officers. The report by this is the squad report, and this has been relied upon. And the report of measurement shows that there is shortfall in Sweden, and this squad report has been relied upon by the inquiry officer, and this has been supplied.
Sir, you have not provided this to
Yes, this report we have supplied.
No.
Yes, ma'am.
Come to that noting in page 7.
He is saying that once we have relied upon this, the collector squad report, and we have supplied that, and we have annexed that document. That is the document we have submitted before my lords. Annexed that page 51. We have supplied that report, and page 7, the report which we have relied that submitted by the collector. He is saying that is report prepared by the SN Patnaik, that we have not relied upon that report. But that is the dispute.
You should be clear then. See, look at the page 11 that...
Yes, well.
Come to page 11.
Page 11.
Even though a straight line.
Yes, even that relates to the previous parameter. That squad report submitted by the collector. And
There's
we have
no distinction made. Just read that.
Sorry. Even the straight line cannot be drawn regarding the maintenance of cost plant, but taking into the area found on measurement, witness of the secretaries and the visit reports of the squad. And the officers and looking into the production of aspect.
Squad and the officers means it's not just the squad, but visits of the officers as well. That's also being relied upon.
Yes, but that
now come to page 7.
Yes, copy of the inquiry report,
No. What is written in the left column?
But he is saying a squad report we have not relied upon. That report we have not relied upon.
Sir, page 11, it says squad and officers. Visits reports of the squad and the officers.
Yes, my squad, you'll also mention the joint squad first, may read my page 11, the first line. By joint squad formed by the collector and by the director involving revenue, means and technical officers. The report of measurements. So this squad report we have relied upon only.
So when you come to that next paragraph, it does not say only this paragraph, only
yes,
this
man, that our case that we have relied upon this report, we have not relied.
No, it talks of and the visit reports.
And this is the report we have annexed to this chapter. Sorry. Plan, but taking into the found measure the witnesses of the secretaries and the visit reports of the squad and the
officers.
And the officers.
So it's not just the report of the squad, but report of the officers also.
And my honorable single judge held that we have not supplied him that squad report.
No, sir. There are 2 sets of reports according to you, correct?
But 4 reports are there. 3 reports. But first,
there's no distinction drawn between these 3 reports. You can go on saying that I've relied only on one report, which I've given him copy of. I have not relied on another report of which there is no copy. But the operative portion in page 11 seems to indicate that everything was relied upon. No distinction is being drawn between report A, report B, report C.
Yes, ma'am. That I'm because what he's saying that a report prepared by the SN Patnaik so and so.
And then on cross-examination.
And that we have not, there is no such report.
No. The report is one part. Cross-examination is also relied upon.
Cross-examination, even though line it by taking into the found measurement, the witness of the secretary.
Now for cross-examination, you come to this part of the
report of the squad and the officers looking into the production aspect.
Mr. Kuntia, for cross-examination to come to page 8. Statements and cross-examinations are marked, right? Are you getting that? Page 8.
Of my affidavit, ma'am.
No. Yes.
Yes. Affidavit. Second paragraph, middle.
Statements and cross-examinations are marked as annexures so and so.
Ma'am.
And then when he asks for it, now come to page 97 of the writ petition. When he asks, I want copy of the cross-examination.
Page 80. Are marked as annexure 1, 2, 3, 4, and 5.
Page 88. The disciplinary authority says there was no cross-examination. How is that possible?
Page.
Subhash Chandra Das has not cross-examined the witness.
No, you'll also see that page 88. Hence, he is seeking copies of the deposition and witness of
cross. Before that, beginning of the paragraph.
Yes, ma'am. I am reading that. Hence, he is seeking copies of deposition of witness.
So you have to go to the beginning of that paragraph.
Yes, ma'am. The Honorable OIT Katak.
No. That paragraph.
88.
Third paragraph, you're reading selectively.
No. Whereas Subhadas has not cross-examined the witnesses during the course of departmental conducted by the inquiry.
1 minute, stop here. Is this correct?
Yes, but this because it is written by my officer. This is correct. This is written by my officer means this is correct. I cannot.
What is this?
I cannot.
Then this inquiry report is also written by your officer only.
Yes, madam.
Then which is correct now?
And has signed.
Which is correct? This is correct or that is correct?
Yes, ma'am. You're also right. My point before
simple for natural justice.
Yes.
You rely on 10 things. You can't keep back any one of those 10 things from the delinquent officer.
Yes,
How
my
is he supposed to
yes,
defend
my-
himself?
My submission before my lord, the honorable single judge has held that only that squad report has not been supplied with for which.
No, there were two things, sir.
No,
One was the cross-examination.
No, that is not the case before the honorable single judge.
No.
Yeah, let me see. That his case is that he has not been supplied with the squad report.
No, not just squad report, sir.
Yes.
Documents relied on in the inquiry.
No, my lord. Yeah, let me see my lord's single judge order.
I have given my lord your lordship's recent judgment.
Okay.
It's Union of India versus Janardhan Mahanti. And so I was privileged to place the matter before your lordship.
Yeah, let me see.
Your lordship, taking into consideration Nirmala J. Jhalal as well as Narayan Dattatreya's judgment, your lordship held the fact-finding inquiry. Unless a copy will be supplied.
No, let him.
My lord. Page 22, my lord.
22.
My lord.
Yes.
Paragraph 2, may I read?
Yes.
Background involving the case is based on a private complaint. A preliminary was conducted, and the report was submitted to the government for taking appropriate decision as against the petition. Based on recommendation of the government, a disciplinary proceeding was initiated against the petitioner. Being not satisfied with the explanation to show that charges were framed and served on petitioner on 21/1/1998. In the meantime, the director textile was appointed as the inquiry officer to inquire into the charges. After conclusion of the inquiry and inquiry report being submitted to the disciplinary authority, petitioner asked to submit his response to the second show cause notice, but in absence of copy of the inquiry report, petitioner got constrained to bring wire number 956C of 2003, requesting therein for a direction to respond number 1 to supply copy of the squad report and copy of the.
It's all relied on, sir. So everywhere he's saying not only inquiry report, copy of deposition.
Yes, ma'am. I'm reading that.
He's been asking for copies of deposition.
Deposition of witness and for submission of response to the second show cause notice.
And then this specifically says page 97 of the brief. The judges even mentioned 97 of the brief. That 97 is that letter which talks of both the squad report and cross-examination.
So supply of squad report and copy of deposition of witness for submission of response to the second.
Both are there, sir.
Yes, ma'am. Petitioner, since was forced to file his response to the second show cause notice, was constrained to file another application bearing OA number 1209C of 2006. This OA was disposed of directing the petitioner to file response even in absence of inquiry report and copy of the deposition. Petitioner filed WP number so and so, which was allowed directing
How many
response.
times he has to come to the court just to get copies? Just see this.
Sorry, ma'am.
Just to get these copies,
Yes, yes.
come twice to the court.
I understand, madam. He has approached my lords several times because of those documents. And that again he approached my lords, and which were allowed directing the respondent to supply copy of the inquiry report and copy of the squad report. In the meantime, the inquiry report was submitted even in absence of supply of the squad report and other documents. Yes. However, by letter that petition was communicated there is no squad report and copy of which is annexed page 97 brief. On 5, the tribunal acquired the second show cause on the ground of non-supply. On 19/7, another show cause notice was served on the petitioner. Petitioner submitted his response on 3. There again involved direction to submit his parawise response to the inquiry.
Okay, just for your information, today he is 74 years old.
Yes, ma'am.
And you're fighting tooth and nail.
Yes.
A 74-year-old man, don't spare him. What is he going to get? Some few hundred more rupees for pension. That's all. Is it worth? Sometimes I wonder. The man has already through his career come 4 times, 5 times to the court just to get documents of an inquiry. You're not sparing him, even now. The present appeal to the state is directed against an order dated 28 July 2022, passed by the learned single judge, allowing writ petition civil (OAC number 3573 of 2013) filed by the respondent, and thereby quashing the inquiry report and disciplinary proceedings, including the order of punishment dated 7th July 2017. Whereby 10%, the punishment imposed was withholding of 10% of the pension of the respondent for 5 years from the date of his superannuation. Paragraph. Among the grounds on which the disciplinary inquiry was challenged was the non-supply of 2 sets of documents. 1, copies of squad reports relied on during the inquiry. And 2, copies of the depositions, which would include cross-examination, transcripts of cross-examination conducted by the respondent delinquent employee of the witnesses of the department. Paragraph. The impugned order of the learned single judge notes that just for the supply of these documents, the respondent had to approach the court, first the Orissa Administrative Tribunal, bracket OAT, and then this court, at least on 2 occasions. Ultimately, in a letter dated Second August 2011, addressed to him by the Deputy Secretary to the Government in the Textile and Handlooms Department. The respondent is informed that the 3 single court squad leaders whose reports he was seeking copies of, open quotation, never conducted inquiry into plantation in the Sarath and Tantia Mohan TRCS and never submitted such a report on the aforesaid 2 plantations. Unquote. Full stop. The respondent was accused of trying to drag on the matter, not allowing the proceedings to complete. And he was still asking for, open quotation, supply of squad reports, which does not exist at all. Unquote. Paragraph. The learned single judge has, after noticing the above response, come to the conclusion that there was a plain violation of the principles of natural justice. Since the inquiry officer did rely on such report, and therefore his conclusions on charges 1 and 4 were not sustainable in law. Paragraph. On the previous occasion, when the present writ appeal was heard, the following order was passed by this court on 11th April 2023. Paragraph. The appellant state has filed an affidavit dated 18th April 2023 placing on record an entire bunch of documents as Annex A series, including copy of a letter dated 4th December 2009 addressed to the respondent on the subject of single quotes, supply of squad reports and other relevant reports pursuant to the order of Honorable High Court dated 3/11/2009 and 17/11/2009. Unquote. This letter lists out 4 documents, and serial number 4 pertains to single quotes, copies of consolidated joint verification report on Tusser plantation of the 5 numbers of joint squad. Just say A to A. Accordingly, Mr. Kuntia, learned AGA submits that it is plain that the squad report copies were indeed supplied to the respondent. Paragraph. Mr. Niranjan Biswal, learned counsel appearing for the respondent, on the other hand, draws attention to the handwritten noting of the respondent beside the above listing of documents in the aforementioned letter, where he mentions that he has not received copies of the squad reports of the squad consisting of Shri S.N. Patnaik, Shri S.K. Acharya, Srimati Namita Biswal, Shri D.P. Dash, and Shri D.P. Dash, since it was not available. Stop. Paragraph. Mr. Kuntia insisted that the aforementioned reports were not relied upon in the inquiry. And what was relied upon was the squad report of 2 officers which was in fact provided to the respondent. Paragraph. Mr. Biswal further points out that he was never provided, the respondent was never provided with copies of the transcript of cross-examination with the disciplinary authority in his letter dated 15th May 2006. Disciplinary authority bracket Commissioner cum Secretary, Department of Textiles and Handloom bracket, maintaining that the respondent, open quotation, maintaining in a letter dated 15th May 2006 that the respondent, single quotes, has not cross-examined the witness during the course of departmental inquiry. Unquote. Full stop. He points out that in the second para of the inquiry report itself, the inquiry officer adverts to the fact that the witnesses of the department, the deposition of the witnesses of the department, open quotation, have been recorded and they were cross-examined by the delinquent. Unquote. Paragraph. The court finds that in the inquiry report, the following observation has been made by the inquiry officer, B to B. Full stop. The above paragraph makes no distinctions between different kinds of squad reports, as sought to be contended by Mr. Kuntia. Full stop. It is therefore not possible to agree with him that the inquiry officer relied only on one set of squad reports and not the other. Full stop. Paragraph. Be that as it may, the inquiry officer certainly relied on the deposition of the witnesses, including their cross-examination, whereas the disciplinary authority seems to think that the respondent never cross-examined any department witness. Full stop. Clearly, the disciplinary authority was wrong in this respect. Full stop. The fact now remains, the fact is evident, it is evident now, even from a reading of the affidavit filed by the department on 18th April 2023. The respondent was not provided with copies of the depositions relied upon by the inquiry officer in the inquiry. Stop. Paragraph. Consequently, this court is unable to find any error having been committed by the learned single judge in interfering with the inquiry proceedings and the conclusions on the ground of failure of the department to supply the respondent delinquent employee documents which were relied upon against him during the inquiry. Full stop. The legal position this case has been has been laid down, following judgments of the Supreme Court of India, by this court. In its judgment dated, it is not reported.
Not reported.
23rd November 2022 in WA 337 of 2019. Bracket Union of India versus Janardhan Mohanty. Paragraph. Finally, the court notes that the respondent is today 74 years old. He's been battling the last more than a decade the department over the disciplinary inquiry, having to already approach the court twice just to seek documents for the purposes of defending himself in the disciplinary inquiry. Full stop. The court fails to understand why, over a punishment of withholding of 10% pension for 5 years on cumulative basis, being set aside by a single judge, the state government would still want to pursue the respondent. Paragraph. For all of the aforementioned reasons, the court finds no reason to interfere with the impugned judgment of the learned single judge.
My only one observation of that judgment, my lord, that one observation that may be set aside, because that honorable single judge has held on retirement the proceeding is closed. That what may follow.
That's okay, sir. That
because
you see, in view of the fact that there were so many, that there is an obvious glaring defect in the disciplinary inquiry, the observation of the learned single judge that it could not have continued after the retirement of the
that part
respondent may come out, even if held to be not correct, would not affect the ultimate conclusion
for future case
that the disciplinary inquiry was in fact vitiated. Full stop. The writ appeal is accordingly dismissed.
Okay. Item 66.
66 my 8th May.
All right.
67.
Job contract 14 September.
All right. 68.
68, my lord.
68 May, please. I am for the respondent.
25th of
There is a
April.
delay of 321 days. Contracted by
COVID.
No COVID, my lord.
What no COVID?
No COVID, my lord. December 28th of March 2022, the order was passed by the Honorable Single Judge. The Lordship may see the judgments.
No. Orders of the Supreme Court in COVID matters continued the stay till beyond that, sir.
No, after 28th, after March.
The Supreme Court continued the stay for even beyond 28 March 22. Up to which date did the Supreme Court continue?
Till June.
Till 1st June.
1st June 22. So you have to start calculating from 1st June 22.
Even your lordship.
Then it gets shortened.
Even your lordship.
What is this first day, is it? First day?
Pertains to regulation. Pertains to regulation of the service of the petitioner. And he has been continuing since February 1993. Also in the verge of retirement, is going to retire in March 2024, my lord.
No. Just tell me, is it first day disposal or?
Yes, my lord.
No.
Lordship also, similar matter, Lordship is calling on 20.
No. It's not a similar matter. It was filed before the London Tribunal. After abolition, it came.
No, but counter was filed at all or not?
Yes. Counter, rejoinder, everything, my lord. Counter, rejoinder, everything.
Lordship may hear it on 25th, my lord. Similar matters are coming.
No.
April.
No, my lord. It's not similar, my lord. It's a different, my lord. It's a person continuing against the existing vacant post since 1993 on ad hoc basis. And my juniors have already been regularized. I have documents. I will show your lordship. Your lordship may see my rejoinder affidavit filed before the Honorable Single Judge. There I have stated, also filed the documents that my juniors, my lords, they have already been regularized by virtue of the orders, by implementation of the orders passed by the London Tribunal, my lords, and confirmed by this Honorable Court. That is their, my lords, document, my lords. It's not similar. It's completely in a different footing. My juniors, my lords, have already been regularized. Lordship may see. There is general affidavit filed before the Honorable Single Judge Mailers. I have given the list and the date of joining of the juniors. They have already been regularized. The orders passed by this honorable court, and I am much senior to them mailers. Therefore, mailers is not similar to any other case mailers, completely different. The person is going to retire mailers in March 2024 mailers. Less than 1 year left to his credit to go for retirement.
Ad hoc basis for 28 years, sir.
My lord, that I realize. I let pass it over, but one pass over at least. One pass over, Lordship, I can indicate.
All right, pass over.
Item 69.
69, 70, 14th September.
All right.
71.
71, 72, 8th May.
Right.
Item 73.
73, 74, 75 are Saptapada, 8th of May.
Right.
76.
76 job contract ballot, 14th of September ballot.
Yes.
Item number 77.
77 was September 8th May.
78.
78 also was same.
79.
79 job contract ballot, 14th of September.
Item number 80.
80 ballot, Saptapada, 8th of May ballot. 81 same.
82.
82 job contract, 14th of September. 83.
83.
83, Lordship, kindly grant 1 week time for removal of defects.
List on 4th July. Defects.
Okay.
Item number 84.
84 old pension 25th April.
Item number 85.
A promotion during pendency of vigilance case 11th May.
Item 86.
The works at 14th September.
87.
Kindly permit to remove the defect something.
List on 5th July. Defects secured.
Item number 88.
88 May 14th September.
Item number 89.
89 word work charge employee, 14th of September.
89.
Work charge employee, 14th September. Oh, 89 is not yours, sir.
89 is a
My lord, there are some private defects. May kindly.
All right.
Private
List on 4th
issues.
July. Defects be cured in the
Item number 90.
90 minute promotion during pendency of vigilance, 11th of May.
All right.
91.
91 and 92 minute, 25th of April, old pension rule.
Item number 92.
91 and 92 is it? That's right.
91, 92.
91, 92 is the same thing.
Minute, old pension rule, minute, 25th of April.
25th April.
For admission, item 93.
93, my lord. I am appearing for the opposite party number 3. Lord, I seek 10 days time, my lord, to file the counter, my lord.
My lord, I am appearing for the opposite party number 2. Already counter prepared. It has sent for vetting, my lord.
Counsel appearing for both opposite parties 2 and 3 seek and are granted 4 weeks time to file their replies as a last chance. Rejoined for the next date. List on. PI list. July. No, sorry. July. 25th July.
Published also.
94.
My lord, they have not complied with the last order, which says that they need to provide the list of transactions pursuant to the ordinance passed by the governor in their counter. They have not stated anything. I have also filed rejoinder to this.
Rejoinder copy has not been
Copy
served.
not.
Already solved.
No, we have not.
Even it's not come on record here. When did you file it?
Rejoinder not.
On 18th, my lord. I have
It's
the
not
receipt
on
also.
record,
I
not
have the receipt also.
It's not on record. Okay. The rejoinder stated to have been filed by the petitioner on 18th April. Be brought on record. Copies thereof be served on counsel for opposite parties. July, sir.
My lord, may I say something? As per the order, they have not stated those transactions in their counter.
It's all right. We'll look into it. Once your rejoinder comes with this. All right.
Obligation.
95.
This relates to a dispute regarding a crematorium ground, my lord. Lordship called for a report. Instead of filing the settlement map, they themselves have prepared a map giving some wrong information, my lord. I have filed the settlement map through an additional affidavit stating that the so-called cremation where they have been taking, it's
Where is the additional affidavit? What is the date of the additional affidavit?
additional affidavit. 16/9/2022.
What happened? You got a copy of that?
16/9/2022.
Because after that, 21st/9. 16/9 filed, be served on Ishwar Mohanty, 17 January.
I have to take instruction on that.
All right, Mr. Mohanty.
You please
further time to take instructions on the additional affidavit dated 16 September 2022 filed by the petitioners. Interim order shall continue based on 27 July.
Item 96.
There's some progress, no?
Opinion
Some
of the,
railway, something I would write about it.
opinion of the government was called for, my lord, as per the last order, lordship.
No, but there's also some on this line. There is some progress, isn't it? Box culvert is required to be constructed underneath the railway line.
So I am appealing for the respondent, my lord, the contesting respondent, my lord. Here, state government's opinion regarding whether a box
They want to file a report in terms of 16(1)(a) of the Railways Act. What happened?
My lord.
The state government was to file a report in terms of section 16(1)(a) of the Railways Act 1989. The report positively be filed before the next date. Interim order to continue. On 27 July.
I am appearing for the respondent no, number 2, my lord. I have already filed my counter.
All right.
My lord, 27 July.
Item 97.
Shorter date, I am suffering the interim order, my lord.
I know. These things take time, so that's the whole problem.
Rainy season comes, it will be difficult to transport the slurry ash to the other end. It will create environmental hazards there. That is why.
They are not filing the report. What do we do? Yes.
97.
With the respondents.
Last time also some adjournment was sought. What's the main matter about?
The matter is the order passed by the Honorable Single Judge relegating the petitioner back to file a civil suit. Lordship pays 15 of the writ appeal.
We'll just pass it over once. All right.
All that they claim is violation of principles of natural justice. They say the Honorable Single Judge has not given them opportunity of hearing. But if your Lordship see the order, we are relegated back to the suit and we have already filed the suit. Suit is pending. This present appellant has already appeared there. So essentially, there nothing remains to be decided here.
We'll just pass it over once.
Your Lordship.
So last time also it didn't appear.
Item number 98.
98 was 14th September.
All right.
Item 99.
May I pay, my lord? The question that call for consideration of your lordship is that whether the undivided estate a specific person can be sold or not in compliance to the Registration Act.
Last time they had sought time for addressing arguments.
Earlier, we have sought for adjournment for filing of the, as it appears. He wants to alienate a undivided portion of a joint family property, which is otherwise barred under section 44 of the TP Act. And the Honorable Single Judge has held that you are not entitled merely because you are a co-sharer, unless it is partitioned and your share is defined by the competent court of law, you cannot sell it. I think there is no infirmity in the judgment passed by the
Lordship, can have that section 44 first.
TP Act. One co-owner.
Madam, when one of the two or more co-owner of a movable property legally compete in that behalf to transfer his share of the such property or interest therein, the transferee acquires as to such share or interest, and so far as it is necessary to give effect the transferor's right to joint possession and other common or part enjoyment of the property, and to enforce partition of the same, but subject to condition of liability affecting on the date of the transfer and sale. So 44 in fact permits sale.
No. What is this property?
It's an agricultural land. It's an agricultural land. So I'm in possession of a specific person, and the law is settled through the full bench of Punjab and Haryana High Court, and then that affirmed by the Honorable Apex Court. I've given the bunch of judgments wherein this that even if I sell the particular portion, but that will not going to be bind, or the ultimately whenever there will be a partition suit, it will be adjusted toward my share and he will get it.
I don't think he'll be ready with the case law. Let him get ready.
My lord?
He may not be ready with all this case law, sir.
I have already given the copy of it long since.
I know.
And your lordship knows that no. And I have stated in my document itself this very same thing.
The counsel for the appellant has already placed on record a bunch of judgments with copies are already given to counsel for the appellant.
Yes, my lord.
Respondent.
No,
it is not there in the brief.
I will
another set thereof be provided
whom he has
to counsel for the respondent to enable him to prepare and make submissions on the next day. List on.
My lord, I prefer a shorter date, a pre-vacation if your lordship pleases.
No, after vacation, sir. 17 July.
In June, sometime.
It's all right.
My love.
It's all right. 17 July. Right.
Item number 100.
On item 100, the vehicle has been released, my lord. I may be permitted to withdraw, my lord.
All right. Counsel for the appellant states that since the vehicle in question has been released, he may be permitted to withdraw the writ appeal. Dismissed as withdrawn.
Well, I have to mention, my lord, item number 7, my lord.
7.
I will permitted to withdraw, my lord.
All right. Dismissed as withdraw. 7.
Passed to matter item number 68.
Paragraph 7 of my.
What has happened is I have gone through this case. Initially was appointed in the 1993.
His main point is his juniors have been regularized.
No, but that's not his case.
Yeah. It is his case. Positive cases, juniors have got regularized. And pursuant to orders of the tribunal.
Also, this honorable court.
In case he has
this honorable court confirmed by this honorable court.
Confirmed by this.
And he has approached the tribunal earlier. Their tribunal has passed an order to allow him to continue on ad hoc basis.
No, we are now on regularization.
Yes, he has that annexed 5 years can find it.
No. How are you discriminating vis-a-vis juniors? His positive cases, juniors went to the tribunal, juniors succeeded. Those orders got confirmed by this court, after which you issued orders regularizing their services.
In that
with the concurrence of the law department.
I'll take
counsel for the respondent refers to the rejoinder filed in WPC bracket OA 3240 of 2013, in which the respondent has enclosed copies of the orders issued by the department regularizing the services of his juniors.
Yes.
Paragraph, counsel for the appellant seeks time to obtain instructions.
Yes, ma'am. I'll take instructions
on the said documents. At his request, list on. We'll have a separate date then for this.
Yes, ma'am.
8 August.
Mallards is ordered, may I pray Mallards because the person is going to retire next month.
When is he retiring?
In the March. In the March 2024, he is going to retire.
Still.
The process will take place, Mallards. Lordship knows at the government level in order to regularize the services.
Or at 25th July.
Yes, obliged.
Passed to matter item 97.
Primarily, he challenging the order passed by the single judge on the ground of natural justice.
He says despite a passover, none appears for the appellant. Even in the previous date, an adjournment had been sought. Dismissed for non-possible. All right. Over.
Supplemental list, trace admission item number 1, CRLMC 1764 of 2019.
May I please, Your Lordship?
Yes.
Your Lordship, I am permitted to withdraw and raise at the appropriate time.
All right. Permitting the petition. Same for 2 also.
Yes, Your Lordship.
1 and 2 both.
Obliged.
Item number 3.
3 permitted to withdraw.
All right.
Item number 4.
Milords, I seek for an accommodation. The conducting counsel father has expired. Milords, I seek for an accommodation. Item number 4, Milords.
Let's see what it is, sir.
Milords. On behalf of DR Sundarai, Milords.
Cognizance. Will permit you to raise all please. Permitting the petitioner to raise all please in the appropriate station.
Item number 5.
May I please, Your Lordship. Your Lordship, there are batch cases of 39 number of CRLMC, Milords. What has happened, I'll just give a short narration of the case, Milords. The case arises out of we are the petitioner's company purchased the patch of land from the vendors. Thereafter, we sold to different persons by plotting the patch of land to different vendors, Milords. Those vendors came up in a complaint that there is a dispute as to the ownership, Milords. Now, what we have done, we have refunded each and every vendor, Milords, individually, and that is on record, Milords. We have refunded them, and now the land still recorded in it. Irony being that, Milords, the vendor, we have paid the vendor, we have paid the vendor, the property still lies with the vendee, and now we are being victimized running before all these criminal cases. Our owners of liability, of financial liability or financial implication has been set aside, my lords. May kindly see, I'll just give one by one, your lordship. Lordship may peruse, wherein it says that I have paid all the amounts that was. I just do not wanted to trouble your lordship with those papers.
See, you've not completed those complainants.
My lords, may kindly peruse the records. Your lordship may be clear that this is on record by the trial court, learned trial court. These are the records of learned trial court, wherein they have stated, the informant themselves have came and stated that we have refunded all the amount to them, my lords.
All right.
It is on all these cases, my lords.
So you want bail on that basis?
Bail, we have been granted bail, my lords, already.
Because of that.
We are just seeking
for apply for discharge then on that same basis.
Yes.
On the same basis you apply for discharge.
Lord says ample power and opportunities.
Why? You can go. You're already there in the trial court. The complainant will also be here. We'll have to now invite the complainant. They have to sweat.
As your lordship pleases. As your lordship.
Here is the property. I'll record this. You say the counsel for the petitioner claims that each of the complainants has already been paid off in full, and this fact has also been brought to the notice of the trial court at the time of grant of bail to the petitioner. In the entire batch of cases, paragraph, it will be open to the petitioner to urge the trial court on the basis of the above development to pass appropriate orders seeking discharge. Full stop. This will be considered, such prayer will be considered on its merits by the trial court in accordance with law.
I'm grateful.
I'm for the informants, all the cases.
So you're agreeing or you're not?
No, that interest part has not been
however, this is disputed.
Yes.
By counsel for the informant who's appearing before this court, and full stop, he states that the interest component
not been paid.
Has not yet been paid to any of the informants.
Let's see. The property question is the Jagannath property.
There is a difference between Amruta. There are two kinds of properties. One is Amruta Manoi properties of Lord Deity, and another is Ekrajat Mahal properties. Amruta Manoi property is of exclusive property of Deity. The property concerned here are the Ekrajat Mahal estate of the property. Let's not go into that part. Yes, please. All these are to that. All right. Yes, I'm grateful. I'm grateful, Milords.
All right. Grateful.
Item number 6.
None appears dismissed.
Item number 7.
Same order.
Item 8.
Same order.
Lordship, item 8, liberty may be granted to raise all the pleas.
All right. Permitting the petition.
Item number 9.
My lord, petitioner pray for passing of the city case number 4,335 or 2017, my lord, pending before the Lord and STGM Bhubaneswar. In spite of complaint case filed, the complaint did not appear till. For that reason, we come before this honorable court.
Why should you come here, sir? There itself they'll close the case, then permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item number 10.
My lord, the petition challenge both the order, Lord Annexer 3 and Annexer 4. My lord, till today, no instruction can you dispose.
No instructions dismissed.
Item number 11.
None appears dismissed.
Item 12.
And may be permitted to withdraw, your lordship.
Dismissed is withdrawn.
Item number 13.
Will be granted to raise the point at the charge, my lord.
Permitting the petition to raise all this.
Item number 14.
None appears dismissed.
Item 15.
Same order.
Item 16.
Same order.
Item number 17.
Same order.
Item number 18.
Same order.
Item 19.
May I please, your lordship? Well, in this case, the petitioner is challenging the petition. I am appearing for the informant. Since 7/1/2020, I have filed the affidavit. The affidavit might have come, but it is not marked in their list, my lord. Subject to your lordship's kind verification, whether affidavit is therein or.
My lord, the petitioners are challenging the order of cognizance on the ground of compromise. Delay dispute.
My lord, matter
You have
has
another
been settled.
copy, you can give it, sir.
Well, I have additional copy. Can I give?
Yes, yes, please. Counsel for the appellant hands over a copy of affidavit of the informant stating that the disputes between the parties have been settled. In that view of the matter, taken the prayer clause and all proceedings consequent thereto hereby quashed. All right.
Obliged. Item number 20.
Made please, Your Lordship, no instructions in this
No
matter.
instructions dismissed.
21.
Your Lordship, kindly have a glance to page 22. This is the medical report, my lord, but the learned court bill has not taken cognizance. For that reason, I am before your Lordship. Arising out of a complaint case, my lord.
What is it? What does this medical report say?
Your Lordship, kindly have a glance to the middle portion. Left hand, some injuries are there. The medical report.
What injuries?
Yes, sorry, Your Lordship. I didn't get.
What are the injuries, sir?
Diagnosis. There is a column, diagnosis. There it was written in the middle.
Soft tissue. What does it say?
Probesh Tariq. The date of admission is 12/3/2019 and date of discharge is 14/3 to for 3 days he admitted in the hospital. Your Lordship.
Soft tissue injury to the back, sir. Nothing. The counsel for the petitioner refers to the medical discharge summary at annexure 4 and assails the impugned order dated
Cognizance order is at page 15.
28/10/2019, passed by the SDJ Mayurbhanj in ICC number, the 1CC number 241 of 2019. But he has taken cognizance.
Sorry.
What is your grievance?
My grievance is that a clear-cut case of 307 is.
No. That to the extent that no cognizance was
For
taken
3
of
days he
offense
admitted in the hospital.
under section 307 IPC paragraph, the medical report only indicates the presence of a soft tissue injury on the back. Full stop. Consequently, the court is not persuaded to
And he
accept
le-
the above plea of the petitioner. The petition is dismissed.
Item 22.
Your Lordship, left hand also broken. That has been written. Why a person will stay 3 days in a hospital, Your Lordship?
All right.
Item 22.
Infructuous, Lordship.
Your Lordship may
Dismissed,
permitted
etc.
to withdraw.
No.
Item 23.
None
23.
appears. None appears dismissed.
26. Item 24.
None appears dismissed.
Item 25.
None appears dismissed.
Item 26.
26, my lord, page 19. Due to non-appearance, non-bailable warrant of arrest was issued.
All right.
They were on
That's
bail.
it for the petitioner states the petitioner will positively appear before the trial court on 1st May 2023. Till then, the NBW issue will not be enforced. Thereafter, it will be open to the petitioner to apply to the trial court for appropriate directions. The petition is disposed of. The interim order is vacated. Oh, there's no interim order, is it? There is?
There was no interim order.
All right. Disposed of.
Item number
May be
27.
allowed to continue on previous bail so that case can be concluded.
We don't know about all that. All right.
27.
Not pressure, Lordship.
Dismissed is not pressed.
Item 28.
May please, Your Lordship, may raise all the points in court below.
All right. Permitting the
All
petition.
right.
to raise all this.
Item 29.
Liberty may be granted to raise all this.
Or same order.
Item 30.
Lordship, liberty may be granted to raise all the pleas.
All right.
31.
None appears dismissed.
Item number 32.
Lordship, I may be permitted to raise those issues before the special court.
All right.
The certified copy may kindly be returned on proper application.
Certified copy of what?
Of documents which have annexed.
All right, originals be returned.
32 in this case, I mean, pardon, 32 in this case, charge has already been framed.
So he's withdrawing it.
Item number 33,
None appears dismissed.
34,
Same order.
35,
Same order.
item 36,
Same order.
37,
37, my lord. The matter has been compromised, my lord. I have filed the flag Q, my lord.
All right.
The
The
compromise.
affidavits of the injured person, informant and the injured person have been placed on record. They have stated that they do not wish to pursue the criminal case against the petitioner as they have settled their disputes. Paragraph in that view of the matter, take from the prayer clause, and all proceedings consequent thereto hereby quashed.
Obliged.
item number 38,
None appears dismissed.
39,
Same order.
item number 40,
Same order.
item 41,
Same order.
item 42,
Same order.
item number 43,
Same order.
item 44,
Same order.
item 45,
Same order.
46,
Same order.
47,
Same order.
item number 48,
Same order.
49, stay. Item 49, sir.
So this is state of Orissa, 49. It's to become infructuous by now.
I pray for next week, man.
No, no, no. The matter concerning release of a seized tractor and trolley in favor of the respondent is the subject matter of the present petition. So the impugn order was passed on 25th June 2018 by the Additional Sessions Judge Patnagar and has not been stayed till date. Full stop. But clearly, the petition has been rendered infructuous due to passage of time. Full stop. It is disposed of as such. Copy of the order be sent to the concerned court.
Item 50,
None appears dismissed.
51,
None appears dismissed.
52,
Same order.
item number 53,
Put the IA in same order.
54,
Same order.
55,
Same order.
item 56,
I may be pardon me, Lord. Item 54.
Yes.
54.
Item 54, my lord. Here I am, my lord, challenging the proceeding initiated against me under 125, my lord. Two documents I will draw your lordship's attention to, my lord. Your lordship may kindly have a glance to page 9.
Yes.
Paragraph 2.
Yes.
This is filed by, my lord, the present opposite party claiming to be my wife.
Right.
Paragraph 2. That the petition number 1 is the legally married wife of the opposite party. Now, my lord, your lordship may kindly have a glance to page 14.
Yes.
Filed by the same petitioner, my lord. Now, your lordship may kindly come to the last paragraph. It is in another proceeding, seeking divorce.
Yes.
That the petitioner is the legally wedded wife of the respondent. Respondent means one Narendra Sharma.
Anyway, you can point us all to the trial court.
My lord?
You can point it out to the trial courts. permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Item number 56,
None appears dismissed.
57,
Same order.
item 58,
Permitted to withdraw.
All right. Dismissed is withdrawn.
item number 15, 59,
None appears dismissed.
Lordship, pardon to make a mention, my lord. Item 47, my lord.
You have to wait. Sir. Yeah.
item 60,
Permitted to withdraw.
Dismissed is withdrawn.
61,
May I please, your lordship? My case of the year 1998, my lord. Petitioner only a simple direction before this honorable court to conclude the trial within specified period, my lord.
That you
In
can
the
make the request.
case of the year 1998, my lord.
All right.
Age of the petitioner is 77 years.
All right.
Since a case was pending, my lord, he is unable to
All right. Permitting the petitioner to raise all pleas, including expediting the proceedings before the trial court. The petition is disposed of. Order.
within 2 to 3 months, my lord, target may be met, my lord.
Not possible, sir. Yes.
Or within
62.
6 months, my lord.
Not possible, sir.
item 62,
None appears dismissed.
63,
Same order.
item number 64,
May I please, my lords. This is a case, my lord, where an application, annexure 1 is the impugned order matter. Annexure 2 is the petition file. It is under 391, 311 CRPC to recall witnesses during appellate stage matter. That during pendency of that application, the appeal was disposed of matter. So what I beg to say that now the revision is pending before this court. So at least I may be permitted to raise this question during hearing of the revision. This only with that liberty, lordship may dispose of.
Permitting the petitioner to raise the pleas raised in the present petition to the appropriate stage in the trial court. The petition is disposed of. All right.
item number 65,
None appears dismissed.
66,
No instruction.
No instructions dismissed.
item 67,
None appears dismissed.
68,
Same order.
69,
Same order.
Infructuous, man.
Infructuous dismissed.
item 70,
Petitioner raised all the point before the trial court.
All right. Permitting the petitioner.
item 71,
This is a matrimonial dispute, my lord. Pray for only the dispute, direct to dispute, expedite us.
All right. Permitting the petitioners to raise all pleas, including expediting the proceedings.
item number 72,
72 nomenclature will have to change. For that reason, I will have to file on IA, your lordship.
It's all right.
So, lordship, I may be permitted to file IA, my lord.
It's all right, sir.
Next week. Next week. Kindly take care of one next week.
So this is which FIR of which date?
Sorry, my lord.
FIR of which date, sir? You want
Actually, the nomenclature should be-
investigation by an independent agency. That's what you say.
Actually,
prayer in the petition is for investigation.
Inaction of police. Inaction of police means I will have to file CRLMP.
You withdraw.
But instead,
Constable, the petitioner seeks leave to withdraw the.
or else your lordship may direct me to approach the court below, raising all the points.
Seek other appropriate remedies as may be permissible to him in accordance with law. Dispose of his withdrawn with liberty is prayed for.
item number 73,
73 millets, it's a matter of matrimonial dispute. And under Annexure 4, Lordship, there is a deed of settlement. And kindly have a glance at the deed of settlement under Annexure 4, Lordship. Page 28.
You can point this out to the trial court, madam.
In it, lots of the deed of settlement is there. At clause 2 of the settlement, it is raised that the second party shall immediately move to Honorable High Court for filing of necessary application under section 482
See, we
to
don't know
quash
if
the.
the other terms have been. What is the date of this?
This is in 2017, lots of.
So we don't know in the last 6 years whether this has been.
No, lots of the fact is that the petitioner is staying at abroad, and the OP number 2, who is the wife, she is in Bangalore, lots of. So give us, let the matter be listed in June or July. The petitioner will come and they will file the affidavit, lots of.
All right. Constable, the petitioner seeks time to produce the affidavits of opposite party number 2. affidavit of opposite party number 2 regarding settlement of disputes. This before the roster bench on 9th May.
Let's say kindly June or July, because it would be difficult in the part of the petitioner to come.
13 July.
Obliged, Lordship.
Item 74.
May it please, Lordship. Let's challenge the present petition has been filed challenging the order of cognizance, my lords. In this case, the company has not been added as an accused, my lords, covered by Lordship's own order, my lords, if I may. In the same case, also, Lordship has already passed.
All right.
The second one.
You can change the numbers.
No, this is the second one. Right. Identical case, same 260 case number, my lord.
Same. All right.
Deeply obliged, my lords.
All right.
Item number 75.
May I please, Your Lordship? Let the revisional order has been challenged in this application, my lord. Lord, admittedly, the opposite party was not in possession of the valid license, my lord. And also, the license which was granted to the opposite party had already expired at the date on the date of seizure of the molasses, my lord. And the Lordship may kindly.
See, anyway, it's now stayed that molasses will not be usable now. This order was stayed. The release order in your favor has been stayed by this court in 2020 itself.
By the criminal case was filed after a duration of 14 months, my lord, from the date of passing of the order.
But stayed. Was it given effect to?
My lords.
It's already been given effect.
Yes, my lords.
When was it given effect to?
My lords, pursuant to the order, the petitioner took the present opposite party took possession of the molasses.
Oh, it is pointed out that the opposite party, opposite party already took possession of the molasses released in his favor by the impugned order of the London Sessions Judge, even before the stay order was passed by this court on 3rd November 2020. In that view of the matter, the present petition has been rendered infructuous, leaving the questions of law arising from the impugned order open for decision in some other appropriate case. The petition is disposed of. All right.
Second case also same, my lords.
Same.
Obliged, my lords.
Item 77.
Please, Your Lordship, this matter, it has been raised in the complaint has been raised in the court of law that the petitioner who is having a furniture shop, he was using the hand saw, but they have treated it as sawmill, and basing on that they have framed charges and filed cases. I had filed to quash the FIR, but if Your Lordship is not inclined to quash, it may be disposed of within a stipulated time.
Correct. Permitting the petitioner to raise all pleas, including expediting the case before the trial court. The petition is disposed of. All right. Both matters.
Item note 78.
78 may be lost, my lord. The present person working at IAC of the Soso police station, my lord. My lord, the opposite part number 2, lodged the missing report before the Soso police station, but the Soso police station IAC did not lodge the missing report. And day after the opposite part number 2 filed a 1/6 case before the law and trial court. The law and trial court taking cognizance against the present petition under section 294, 323, 506 of IPC, my lord. But my kindly see Annex 3, the IAC already missing report laws and already circular the register of Keonjhar, my lord.
Point out also, permitting the petitioner raise all please. Right.
Item 79.
Permitted to withdraw. Dismiss, withdraw.
Item 80.
None appears dismissed.
Item 47.
Lordship, item 47 in putting it shows that the nomenclature may be changed to criminal revision, my lord. So next one type to filing one IF, my lord.
No. Just withdraw. And what is the matter about?
It is a 125, section 125 of CRPC passed an ex parte order. On that ground, which challenges the ex parte order, my lord.
So this must have been asking you to pay some interim maintenance.
My lord.
Are you complying with that order? Are you complying with it or not? You have to pay intermaintenance of how much rupees?
That is no instructions, sir.
No. Under the impugned order, what was the amount to be paid? Nothing. It's only setting you ex parte. Nothing is happening.
My lord. Yeah, so 50,000, my lord.
8,000. 5,000, not 50,000, sir. Monthly maintenance of 5,000.
5,000.
Considering that the monthly maintenance that to be paid is just 5,000 per month. And the order was passed way back on 26th October 2016 by the JMFC Karanjia in CMC 97 of 2014. And with the said order not having stayed till date, the court is not inclined to interfere in the matter. Moreover, what has been ordered is only an intermaintenance subject to further revisions according to the changing circumstances. For all of the aforementioned reasons, court is not persuaded to interfere with the impugned order. The petition is dismissed.